Good day, my name is Mark Malore. I'm a partner principal here at the Malore Law Firm. I wanted to speak with you specifically about the differences in Chapter 7 and Chapter 13 bankruptcy. A lot of my clients in Corona have that question in particular: what are the differences and what should I be using when I'm thinking about strategically dealing with my debt carry? And so I wanted to give you this brief overview to give you some of those distinctions between the two and what the two mean necessarily. So a lot of clients in California or Corona that are facing bankruptcy want to know whether they should file Chapter 7 and Chapter 13. What are the differences? Chapter 7 is a discharge of all the debtor's debt. So all the creditors get to pound sand, if you will, and they don't take anything on the debt. That's unsecured debt. Secured debt is something else. Chapter 13 bankruptcy is a repayment plan. The repayment plan is either 10 cents on the dollar all the way up to 100 cents on the dollar. It really depends on your gross monthly income and the amount of debt you're carrying in order for the trustee to determine what kind of repayment plan you're going to be under and how long that plan is going to be. Which brings me to the second distinction between the two. In a Chapter 7 bankruptcy, those are usually completed from the date of filing to the date of discharge by the bankruptcy court from your debt in about 90 to 120 days. Whereas a Chapter 13 bankruptcy from the date of filing to the date of discharge takes about 3 to 5 years. You might ask, why does it take so long? Well, number one, you're repaying the debt of a certain percentage for 3 to 5 years to repay that back to your creditors. And whereas the Chapter 7, there is no repayment, so it's just the debtors get to say goodbye, or you get to say goodbye to your debtors, and the debt is discharged as a result. So not only do they take less time, but they're more efficient in terms of discharging the debt. There's no repayment. Finally, I think an important distinction to be made between the two is when can you file. The distinction to be made on that in particular is with respect to how much money you make. If you make below the California median average income, then you can file and you have available to you the Chapter 7 option to discharge all your debt. If you make above the California median income for the year, then you are going to be forced into filing a Chapter 13 bankruptcy if bankruptcy is an option for you. And that's going to force you into a repayment plan to do that. Finally, I think in these economic times, one other area is also important to mention in terms of the distinctions between the two. And there are many major and minor distinctions. I just want to highlight a few to you here. But one of the most major distinctions in this economic time is the area of strategic default: loan modification, foreclosure, short sale. What do you do with a home that you may want to keep, but in its encumbered state is only worth 50% of what you have encumbering the home? In other words, most of my Corona clients have homes with $500,000 worth of mortgage debt encumbering the home, and the home's only worth $250,000. We're down 50% here in the Inland Empire, and so Corona's been affected. Corona homeowners have been affected, like most of the people in Southern California, with this sort of phenomenon. What do you do in those cases? Well, under certain circumstances, you can discharge the second from your home, or rather expunge the second lien on your home. We call that lien stripping. It's a attorney lingo, if you will, but lien stripping is the process by which you strip or remove the second from your home after your bankruptcy discharge. How do you do that? Well, the final distinction I want to talk to you about today is the difference between Chapter 7 and Chapter 13, because when it comes to lien stripping, you can only strip the second from your home by filing a Chapter 13. Lien stripping is not available to you with a Chapter 7 filing. So if part of your economic plan and strategic default plan is to remove the second encumbrance from your home, as well as discharging your debt, you're going to have to file a Chapter 13 bankruptcy that's going to allow you to strip the second from your home. The value of your home has to be below the value of your first in order to do so, but if that's the case, you should be able to strip the second, get an order to strip the second after your debt has been discharged during this 3 to 5 year period, after that's your repayment plan is complete. If that's the case, and it makes more financial sense for you to discharge the second on your home and repay a certain portion of your debt in a Chapter 13, That may be an option you choose in order to deal with your debt carry and debt load, and also bring an immediate equity position back into your home. If you've got a $100,000 second, stripping the second from your home immediately injects another $100,000 of equity back in your home, so you don't have as long to wait to gain that equity back over the next 10 to 12 years for that equity line to come back to your home, and you'll be cash flowing or be positive in your home in terms of its equity to debt ratios right away. So yet another distinction between Chapter 7 and Chapter 13, and also an important one for you to think about. If you have any other questions or want to apply the facts to your particular situation, feel free to come and meet with myself or my partner Alan Sanders. We'd be happy to talk to you about those options in relationship to your specific facts. Thank you for your attention.